So this starts, as all good Republicans talks ought to start, with the Constitution. And the Constitution has very specific rules for taking a property, when they can use eminent domain to take your property. And it's in the Fifth Amendment. Just start with the right place. Let's start with and read it. It says, "Nor shall private property be taken for public use without just compensation." Now, there are parts of this that I think lawyers make very complicated. There are even parts that are pretty complicated. This is not one of those complicated places. Nor shall property be taken, nor shall private property be taken for public use without just compensation. Now, the problem with that is, and for 200 years that was fine. Everybody knew what that meant. They could only take your property for public use, like a road, maybe a police station, a school, something the public actually used, public use. Now, what happened with the last couple of decades is the Supreme Court started to slide, started to slip on what they meant when they were protecting your rights under the Constitution. So everybody's very familiar with the Obamacare case, but there was a previous case that would be, I guess, was the worst case of the century until the Obamacare case came along. This was the Kelo decision. The Kelo decision involves a government that wanted to take somebody's property. It was Suzette Kelo. She had a house in New London, Connecticut. And they wanted to redevelop the whole several city blocks. She said, "I don't want to sell." They said, "No, we really want you to sell." She said, "I don't want to sell." They said, "No, you don't understand. We need you to sell." She said, "Too bad, it's my house." And what they did is they took it. They took her property and they gave it to a developer that included Pfizer, which is what everybody knows, the big drug company. And Suzette Kelo said, "Absolutely not." And she fought them all the way up to the Supreme Court. And to the dismay of anybody that believes in the Constitution, the Supreme Court said, "You know, public use is pretty limiting. We're going to change that to public purpose." And this doesn't sound like a major change. Public use, public purpose, public use, public purpose. Except it really is, because public use had an understanding. Public use meant a road, something the public could use. Public purpose meant whatever your public officials said it was. So connect the dots. What you've done is you've said that politicians can define what public purpose is. Public purpose is enough to take your property. Therefore, the government can take your property and give it to somebody else. That was the Kelo decision. It took place in 2005. Ever since, there's been a group of us in the General Assembly who have been trying to give you back the rights you thought you already had. And that's what this endeavor is. Now, 2007, we passed a new law. Ken Cuccinelli was in the Senate. I was in the House. We both had our halves of it. We passed a new law to protect your rights. The problem with the law is that it can always be changed. The next General Assembly can come in and take it away. The plan was always to put it in the Constitution. So in 2007, I had the resolution to put it in the Constitution, and I failed. We were 4 votes shy of the Senate, and we couldn't get it passed. Brought it back in 2009, failed. Brought it back in 2010, failed. Finally, in 2011, we had some brave Democrats, including one from Portsmouth named Johnny Gioano. With his help, we were able to get it out of the Senate subcommittee, which had been killing it by 1 vote. I guess the full committee had been killing it. We got out of the full committee by 1 vote. Got it to the floor of the Senate, and it narrowly passed. We then got it to the full Senate the second year, and it passed, and now it's coming to you.